The Fourth Amendment protects against unreasonable searches and seizures. In the last couple of weeks, I went through cases that were defining what is a search under the Fourth Amendment. And now we're moving on to what the Constitution instructs us to do when we deem something a search, which is get a warrant. The case is Johnson versus United States, a 1948 Supreme Court case. Here's the facts. We have a confidential informant who calls the federal agents and tells them that there is an individual in a hotel room that's smoking opium. Several agents go out to the scene. As they're walking the hotel room, they can smell opium coming from one of the rooms. So they come up, they knock on the door, and they talk to individual, asking her about the smell. She of course denies and says there is no smell coming from her room. So at that point, the federal agent says that she's under arrest and they're gonna come in and search the hotel room. During the search, they find opium and the apparatus that's being used to smoke that opium. The Fourth Amendment protects against unreasonable searches and seizures. And in this case, we clearly have a search. We have federal agents who are entering somebody else's hotel room, searching it and finding evidence of the crime. You might even say that these agents had probable cause to search the hotel room, and you might be right. After all, these agents were trained in narcotics and they could smell the evidence of the crime, which is the smell of opium coming from that hotel room. They also had that informant who told them that these individuals will be smoking opium in the hotel room. But the evidence in this case is not going to be suppressed because of the lack of probable cause. The Supreme Court tells us that it's going to be suppressed because overzealous police officers often forget the point of the Fourth Amendment. It's not that the federal agents cannot make reasonable inferences and draw conclusions in order to find probable cause. The point of the Fourth Amendment is that they have to get those inferences together and present them to a neutral and separate magistrate who will then make a determination if probable cause exists. And if it does, that judge will issue a warrant. And then the federal agents can go ahead and search whatever place they request. Only if there is probable cause and only if the judge determines that it exists. The government did not present any reasons why the federal agents could not get a warrant in this case, aside from the fact that it was inconvenient and it would take longer for them to get a warrant. But of course, those are not good excuses. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.